Hello and welcome to the second in our employment podcast series with me, Daryl Smith, and
myself, Ian Abel.
Yeah, and in this one today we'll be studying the unfair dismissal basics number 2, so just going on further from the first podcast. So we've already had a look at the 5 fair reasons for dismissal. We'll now consider the reasonableness of the decision. So once a fair reason has been established for the dismissal, an employer must act reasonably in dismissing the employee for that reason. The test for reasonableness is found in statute and is effectively broken into 2 steps. The first being, did the employer follow a fair process? The second being, did the employer act reasonably in treating the reason as a sufficient reason for dismissal? Let's look at these 2 elements in a little bit more detail here.
Thanks, Daryl. So I'll cover what is a fair process. The starting point of any process should be the ACAS Code for Conduct, and we will put a little link for you up on the screen at the moment, so you should be able to click on that and find your way through to the code. The code is applicable for dismissals for conduct and capability only, so it specifically excludes redundancy and the expiry of a fixed term contract. So if the process is related to either of those, the code shouldn't be followed. Basically, the essence of the code are the following principles, which is to investigate the issues, to inform the employee in writing of those issues, conduct a fair disciplinary hearing, and then inform the employee of any decision in writing and include a right of appeal. So an example of that may well be if you were accusing somebody of theft. Daryl touched on this as one of the 5 fair reasons under conduct in one of the previous podcasts. So if somebody had been allegedly stealing from work, a fair process would be to conduct an investigation. So that might include speaking to witnesses who may have seen the conduct, or hopefully these days looking at CCTV footage. You would then write to the employee, providing them a copy of any evidence that you've got. So in the CCTV example, perhaps a copy of it, of them rifling through the till or putting their hands in the safe if it was theft. Invite them to a disciplinary hearing and put the outcome or any potential outcome of the hearing in the invite letter. Hold the hearing, give the employee a fair chance to make any points in mitigation, such as, I don't know, there's not really a good mitigation for stealing, but they're doing it because to feed their family or something along those lines. And then after you have made a decision, inform the employee of that decision in writing and to include a right of appeal. So the right of appeal from a practical point of view should be somebody higher up in the organisation. So it may well be that a line manager or some member of management would conduct the initial disciplinary, and maybe a director or the boss, the MD, might be kept back for the right of appeal.
So Ian's just covered there the first of the 2 elements with regards to a fair process. The second, as I've said previously, is whether the employer acted reasonably. The test as to whether the employer acted reasonably is an objective one, but very well established case law has led to the test being for the tribunal to consider whether the employer's decision to dismiss fell within the range of reasonable responses that a reasonable employer in those circumstances and in that business might have adopted. The test applies to both the decision to dismiss but also the investigation which actually led to that initial decision.
Thanks, Daryl. So that's the end of our second podcast. We've now covered the basics of unfair dismissal over the last 2 podcasts, and we'll move on to automatic unfair dismissal, I think, in our next instalment. But thank you very much for listening. Again, we appreciate any feedback, constructive or otherwise, and hope you've enjoyed. Thanks very much.
Oakwood Solicitors, the experts in employment law claims. For any inquiries, please call 0113 200 9787 or email us at enquiries@oakwoodsolicitors.co.uk. Anything contained in this podcast is for information purposes only and not intended to be specific legal advice.